fighting out of Toronto, Canada. He is the bodybuilding champion of the world, presenting James Hurricane Hergott.
James Hergott here with Love and Muscle, and this is a special episode that we're dedicating to dealing with family court and custody and matters, to deal with that. So, we're privileged to have today Brian Ludmer. Am I getting your name right?
Yes, you are.
Okay, and he's a family attorney who specializes in high conflict, custody battles, divorce, things like that. He's written books on it. He's one of the writers, is that the right way to say it, of a bill?
Drafter, I guess.
Drafters, yes, of a bill that was put before Parliament in terms of shared custody. And he's really an expert on family court, on shared custody, and all of these things. Am I missing anything in my depiction of you here, Brian?
No, that's fine. I also have 30 years of business law experience.
Very cool. Well, for the purposes of what we're doing here, we're all talking about families, relationships, things like that. So my first question is, you wrote a book on high conflict, and look, to me, you have to, one way or the other, co-parent with the other person. I mean, even if there's a decision that comes down, a final decision, at the end of the day, there's all these things like your kid can get sick, your kid can have problems in school later in life. In fact, there's even the type of situation where maybe the person who has sole custody, the teenage years come and that child becomes a teenager and turns against the one that has sole custody. And I feel that when people get into these conflicts, they're thinking about, a very short distance into the future, and they're not thinking about this long-term thing. And even long after the attorneys or the arbitrators or the judges are in the picture, you still have somebody that you have to deal with. So tell me, why is it that people get into these high conflict situations and can't see the forest through the trees, so to speak, and think about the long-term best interest of the child and just figure out some way to get along?
I guess the reason why these families struggle to restructure in a healthy manner is perhaps the same dynamic that led them to break up in the first place. Sometimes it's a lack of a common vision on parenting, or they were battling over money, or they were battling over control, and those dynamics continue to spill over into the separated family, and it's made worse by the fact that they're not together and they're not forced to operate in unison for the children. So we have, while the family's together, even though there may be some battles, the two parents will back each other up in any parenting decision, because otherwise the kids are just going to play one parent off against the other. Suddenly, when the family separates, there's no unison anymore, and it becomes a battle for the allegiance of the children sometimes. So these families are struggling, and it's up to the system to reimpose a structure to protect the kids from that.
Well, it's a sad thing because, ultimately if we lived in the perfect universe, it would be everything's in the best interest of the child. And unfortunately, that's not the case. Now, in my personal, I'm involved in a custody situation, but I don't really want to get into it too much because it's not about me. But I will say this. I expected that when you go into to trial, or you go into family court, that the presumption would be, hey, it's 50% your DNA, it's 50% the woman's DNA. The children are split up 50-50. And I found out that's not really the case that it is. I mean, that would only make logical sense to me, given that we're supposed to be a society of equality. So, first of all, Why isn't that the case? And second of all, what is kind of the default at this time?
Well, most jurisdictions have a generalized best interests of the child standard, and then just a list of certain criteria that a court would look at in trying to decide off a blank canvas what sort of parenting plan to impose on parents who can't otherwise agree. There is in our Federal Divorce Act a clause that requires a court to consider the maximum contact possible for both parents, but that has not been interpreted as meaning a starting point of equal shared parenting. So it does come as a surprise to many people after they get separated that they could have been a very involved parent, and now the system is telling them how much time they're going to have with their child, and a very, very difficult situation. So I would say that the reason why we don't yet have equal shared parenting, at least as a starting point in the analysis, is just the assumption that we need some sort of customized parenting plan for every single family. And those who would support equal shared parenting as a starting point don't agree with that. They rely on social science literature and just actual experience with separating families to state that for the vast majority of families, there's no basis, no evidence-based way to look at this as supporting the search for some perfect parenting plan where one parent has the children 37.5% of the time, and someone's going to conclude that that's optimal. So the majority of the peer review research would actually support the view that the closer we get to two primary parents and two equal parents, usually that's the best outcome. So if that's the starting point, we could then have customized solutions only for those families that, strictly speaking, need it. So one example we gave when we were lobbying the federal parliament was if somebody travels a lot on business, equal shared parenting might not work. If somebody has very difficult shift work without the family support to cover, it probably won't work. If somebody's struggling with alcoholism, it probably won't work. But for the vast majority of families with two normal parents, the peer review social science literature would suggest the closer we get to two equal parents, the better the outcomes for the children.
Right, and I know that there was a study in Sweden about joint custody, and I believe, and correct me if I'm wrong, that it was even shown that even if there was, a lot of travel back and forth between the households, it was still better for the children. And of course, I'm well aware of the statistics of fatherlessness, that the father's not in the picture. Can you tell me any of the studies that you're aware of, and why the courts are so kind of slow to adopt, this information and to take it into consideration?
Well, I first refer people to the website of the Canadian Equal Parenting Coalition, which is the umbrella group for multiple shared parenting organizations in Canada, as well as the website of Lawyers for Equal Shared Parenting and the website of Leading Women for Shared Parenting. There'll be a list of some of these studies that I referred to on each of those websites, sometimes with links to the actual study itself. So that's a good place to start if you're looking for this backup. And in each particular case, if you can show that the parenting plan would work and that you're a normal, interested, educated, parent willing and able to devote the time that equal parenting requires, you're increasingly going to meet with a favorable reception from the court system. There's a substantial body of jurisprudence now on equal shared parenting, some of them indicating a broader set of criteria that courts look at to determine what sort of parenting plan is optimal. So in other words, fleshing out what good parenting actually means. And you can point to that growing body of jurisprudence. As to why it's not more pervasive yet, it's simply a matter of education. That those mental health practitioners with involvement with the family system need to study up on that research. And the direct participants in the court system, lawyers and judges, need to review that research, which is quite accessible now. So as that knowledge spreads, and as the harm that custody litigation causes to children becomes more widely known, I think we'll continue to see an evolution. What the proponents of legislative change are trying to do is accelerate that process to have not a rigid rule of 50-50, but rather that the starting point in any family, till someone identifies some serious issues that cannot be solved other than an unweighted schedule, the starting point is equal shared parenting. And some of the Scandinavian countries are there. There's proposals in this regard in several states in the United States. Arizona has currently, I think, a 35% floor for normative parenting situations. They're studying those early results. Australia had a change in their legislation about 7-8 years ago that increased the likelihood of shared parenting. So it is the long-term trend. Still work to do, but if we hope to protect children from these difficult situations, it's where we're going to have to go.
Understood. And one of the things I'm going to do is I'm going to include the links below to the sites and that you indicated, so that's easy for people to click on. So where are we at with the legislation aspect of it? I know that there was a bill that you and Coleman and other attorneys had put forth. It didn't go forward. Is there a future of this? Kind of where are we at this point in time from a legislation point of view?
Once again, I think the efforts will be spearheaded by Glenn Sheridan, who's the head of CEPC, and that coalition will probably be at the forefront of the next round of efforts. There is no formal proposal on the table now. I think what we all learned from the 2014 exercise, which was a bill sponsored by a conservative backbencher while the conservatives were in power, is that you need actual party backing if you're going to see this through. So we have a lot of work to do with the three parties and their formal platforms, a lot of education to do within the Department of Justice. And then we would hope ultimately this moves forward with the consent and sponsorship of at least one of the parties. And if it can pass second reading, which is where the previous bill died, and we can get it into committee, and then have the authors of all of these studies come forward and explain, we may have a good shot of ultimately getting this passed in Canada. So that's the current plan, to my knowledge.
And let's take it from that kind of level to more of a micro level at this point. So let's say you're somebody like myself and you're in the family court system, or you're going to be in the family court system. What can somebody do at this point in time to try and achieve shared parenting. I mean, I know that the statistics aren't that favorable to men specifically, that it's very difficult to get, certainly I think it's only 7% of the cases do men get sole custody. So, large part of the time, women get sole custody. What are kind of some of the things that you would recommend for the average person that's out there that, is simply a loving person that wants to have access to the child and have an equal share in the decision making, and there's resistance from, the opposite side?
Well, there's several things you can do. The first is you can take parenting courses, and there's a long list of parenting books, both general and on specific topics, that you can read. You can make sure you're always available for the child when you get your parenting time, and you can make sure you're the best parent you can be, and provide a strong moral, spiritual, and other guidance background for the child. Make sure you have lots of witnesses to that who would be able to speak for you, and try and be the best co-parent you can be, even if you're facing difficulties. Be the one leading by example about inclusiveness, transparency, communication, and calmness in the face of the storm. And those are all things that, if you can't settle your case and an adjudication is required, will certainly serve you in good stead. So those are the things we can control. What we can't control is the extent of resistance from the other parent who might feel they must be the primary parent. Can't really control that. So if you have good counsel who's aware of the peer review literature, and you might even bring in an expert to speak about that to the court, and the jurisprudence is there, then you've got a decent shot. Now, how hard and do you have to push this to the end? Canada has one of the world's leading experts in this sort of research, Professor Hergott at UBC, and he's published several interesting studies. So basically, if you can have your kids almost half-time, that last little bit probably won't make a difference in their experience with you and your experience with them. You'll still be viewed as a primary parent. So sometimes having just shy of 50% gives the other parent the feeling they want, that they're the primary parent, and yet you're close enough that your child will view you as much of a parent as the other parent over the long term. So some perspective sometimes helps as well.
Good advice. And now you talked about like the stats and like the case law. I think that's what you were referring to with jurisprudence. Where would somebody find that kind of information if they were looking for it?
There's a publicly available website of all Canadian jurisprudence called CANLI, CANLII.org. And, you'll unfortunately, unless you're very careful with your search terms, you'll get a huge number of hits. But there are summaries and papers done, and once somebody compiles some case law into a summary and uses it in one case, that tends to get redistributed around. If you have a good lawyer, they shouldn't be researching this from scratch. They should have a fairly up-to-date summary of this law already. And it's important then to review it and see what is it that courts will look at in deciding that it is a situation that requires equal parenting, and you try and satisfy as many of those criteria as possible. And as I said, educate yourself and take care of yourself and be the best parent you can be, and love those children.
That's great advice, whether you're in a custody situation or a family court situation, or even if you're just being a parent. So that's a good thing. Do you know Kaplanis versus Kaplanis?
Yes, well-known case. Now, it's important, the terminology is important because when people talk about shared custody, technically the word custody, that deals with decision-making authority on major issues. What I've been talking about so far in terms of shared parenting is equal parenting time, which is actually the thing that's of most importance to people. So Kaplanis dealt primarily with the decision-making aspect, which is a completely different paradigm, because you could have one parent with final decision-making authority on the major issues, medical, religion, education, and yet still have equal time. So it is important to understand whether you're talking about decision-making or whether you're talking about parenting time. And in terms of decision-making, for the average family, that's usually not where the problem is. If there's not likely to be any issue in future about where and how the child's educated, there's a common vision, or what religion the child will be raised in, and there aren't any really major medical issues on the horizon, then quite often the battle over custody is a little bit of a misplaced effort, and people should be thinking more about the parenting time issue. And there's ways to deal with the custody issue through parenting coordinators, parallel parenting, where you divide up the major topics between the two parents, or you just put certain limits on the decision-making authority of the parent who will have final decision-making power, so that they really can't do anything that's going to upset your life with the child. For example, even if somebody has primary custody, we would often put a restriction on mobility, because that could undermine the parenting timeshare that's otherwise negotiated. So there's ways to deal with it without getting into a big battle on custody, and the primary focus should be on parenting time.
Well, the interesting thing is they say that, in terms of politics, probably somebody that wants power should be the last one to have it. And one thing that I find interesting in the people that I know that are in custody battles, a lot of times the person who wants control probably should be the last one to have it, because the more reasonable person that's like, hey, let's just get along and talk things out, is kind of not the one that's seeking that kind of power. Do you find any irony in that, or is that something you kind of see in your practice?
Well, I certainly see the irony in what you're saying, and there is case law that says one of the situations where even if two parents aren't getting along, and it's hard to imagine them making decisions together because the dialogue is so strained, the court will still order joint decision making, where the fear is that one parent would use decision making to marginalize the other parent. So both from the statute and the jurisprudence, if there's a concern about one parent misusing final decision making, then the court is supposed to make sure that they don't have unrestricted final decision making, and it may solve that by going with joint custody.
Very very good information. Now, when you were putting this bill forward, from what I understand, and correct me if I'm wrong, one of the opponents to it was the Bar Association. Is that a correct statement? And if so, what was kind of their what was their stake in the situation?
Well, there were representations from the bar associations opposing the bill. This is not exclusive to Canada. Similar opposition has been experienced in other jurisdictions trying to bring in equal shared parenting. The argument generally is that, and it's misstated, that somehow these initiatives are meant to impose a one-size-fits-all solution. And that's just absolutely wrong, because the legislation just was bringing in a rebuttable presumption of equal shared parenting. So the examples I gave before of shift work or somebody traveling on business all the time or an alcohol problem would still be issues that a court would say, not for this family. There are issues that equal shared parenting, it's just not going to work. So we really did have answers to just about every objection raised. Possibly that process started just a little bit too late for the responses to get to the key decision makers. But nothing was raised that's an insurmountable problem. So the concern is, how do we even educate the family law bar so that people see that concerns raised are misplaced, and then we can all approach the government with a unified voice. Now the public gets it. In all of the survey work that we put in terms of broadly recognized opinion polls, more than 80% of the Canadian public across every demographic, by age, by region, by political affiliation, and by gender, supports this initiative. The public understands that we're not doing justice to children in these situations. The public understands the obvious common sense answer here, which is a starting point of equal shared parenting. So we really just need the decision makers to heed the voice of the public. And when that starts to sink in, we may get more of a reaction as well.
Right, and where I think that really is going to take off is, one of my concerns is the future of the family. I mean, we have, for the first time, more unmarried couples than married. We spoke about the effects of fatherlessness. So you're having essentially the nuclear family kind of ripped apart, because let's face it, there's not a lot of incentives anymore to keep the marriage together. And if there's a biased system, I don't think I'm speaking out of turn here, that 70% of divorces are initiated by women, and I think it's approximately 80% of cases are brought by women, in terms of family court. So, and I would, I would put forth to you that the reason for that is that their outcome is usually better than the man's in these situations, even though we're on the face of it supposed to have equality. However, as you know, there's often a moral hazard component of things, and one of the things that I've seen happen is a number of men my age who are essentially opting out of wanting to get married, wanting to have children, wanting to do any of these things. And I know a lot of single women in their 40s and 30s that are having trouble finding a guy that wants to settle down. So if you take all the incentives out of the situation, and you have a system that's too biased, you're going to have a situation where people aren't going to want to settle down and get married. And then what happens to society as a whole? I know that's a bit of a rant, but if you could comment on any of the things that I had to say there.
Okay. I think the problem we're discussing here, in a sense, has nothing to do with whether people get married or not, because the issue is similarly there for couples who have children and have, for whatever reason, decided not to get married.
Well, sorry to interrupt, but birth rates
Sure.
are declining as well. So,
Yes.
And we're having more and more single parent homes. Continue.
Correct. But in terms of this specific issue, what does the family law system, the justice system, say to couples, whether married or not, who are getting separated and have one or more children if they can't settle it themselves? So we have that issue, that struggle, regardless of whether the couple had been married or not. So the focus is really on a point you made at the outset of this interview. You have two parents involved in the child's life, and they mix up their roles. One might be working late one week, the other the next week, and it just all works seamlessly, and they're both 100% involved in the child's life. Why, after separation, are we telling one they need to kind of take a back seat? And that issue's there regardless of whether they're married or not. The concern that I can see is if there are certain assumptions that regardless of gender, the stay-at-home parent should be the primary parent after a separation, then that is going to raise the risk that everyone is going to say we need daycare or a nanny or family care at the earliest possible date. Both parents have to work, even if that's not economically required, or even if that might not be ideal for the child, because of the risk of being marginalized if you're not the stay-at-home parent. That's the risk that I see, and it flows from the paradigm that even though the legislation doesn't say that a stay-at-home parent should be at an advantage post-separation, that seems to be the biggest influence in some cases. And interestingly, in today's world, the stay-at-home parent could be the father or the mother. So in today's world, with modern educated women working, some of the statistics about increasing rates of unemployment for men, the old historical paradigms might not work for women either. So a more broad-based view of, do we have two normal parents? Why are we looking for a primary parent instead of looking for two primary parents? I think long-term is going to serve not only the needs of the children, but the desires of the parents as well. So those are the risks, as well as the conflict itself, and the money wasted during the conflict is quite a burden not only on the family, but on society as well. It is a very, very expensive system indeed, that just may not be serving its constituents well today. As for incentives for people to have kids, I'd like to think that that's such a powerful primal desire, that parenting being one of the greatest things we can do, people are still going to have kids, regardless of how flawed the current system might be. It's how do we protect those children from the flaws in the current system, and how do we substantially decrease the amount of litigation that's going on now. That's the challenge.
Correct. Though I would say that a couple of major changes that have occurred is, one, you have, the birth control pill, and second of all, you have, just as more anecdotal evidence than anything, but our birth rates are declining. I know just a ton of men that see the system, and they see what happened to their fathers and different things within family court and with child support and different things like that. And they're just like, hey, I'm not having kids. and they're kind of it's a huge problem in Japan, for example. But there's actual movements like the MGTOW movement and things like that where men are basically essentially going on strike and saying we're not going to have children, we're just going to play video games and watch porn and sleep around and stuff like that. And it's kind of blamed on men, like, why don't you grow up and have a family? But the reality is that there's a number of elements within society that are reducing the desire for people to do that. And I know this isn't your area of expertise, but me myself, just as an individual, if I felt that the system was more fair, if the rumor was that the system was more fair, I'd feel more in a better spot about having children and about settling down and not be so fearful. I mean, you all know the statistics on suicide, that a lot of men commit suicide that are part of the divorce and family court system. I mean, it's a real thing that a lot of people face, and not everybody has the moxie to kind of be able to speak. Some men might just opt out. They may be part of a high conflict situation, as you would call it, from the other side, and just be like, yeah, I'll pay my child support, but I'm not going to participate in the child's life because it's too much of a hassle dealing with this ex. So I think there's a number of moral hazards that are out there being created that I'm hoping will be reversed.
Well, if we do get a rebuttable presumption of equal shared parenting, it will inevitably lead to more father inclusiveness. People will have the confidence that they can stay in their child's life post-separation, and there will be much less of a hurdle to doing so after separation. So that's one of the hoped for benefits from the legislation.
And in terms of society changing, more women are graduating university now than men. So we're having a number of really changes in things which aren't really reflected in kind of the old model system. What can people do to help this movement? Because you say that a large 80% plus of society believes this. Is there anything they can do to contribute to this cause or to help it in some manner at this time?
Certainly. First, in terms of awareness, they can make their voice heard to their local MP and their local MPP. Secondly, they can get involved with and become supporters of the various organizations that are trying to advance knowledge and law in this area, including Canadian Equal Parenting Coalition and its member organizations right across the country. There's the Canadian Association for Equality based here in Toronto. All of these organizations welcome additional volunteers. They certainly welcome your donations. Several of them are registered with Canada Revenue Agency as registered charities, can give receipts. But they really would value your time and energy and certainly your voice. Come on out to their events and speak up in the press and let your voice be heard by your representatives in Parliament and the provincial legislatures.
Yeah, and let's face it, not to get overly political here, but there was Brexit and there's different things, and I know that that's not related to this endeavor whatsoever, but I'm just saying sometimes there can be change in society that things don't always have to be the way it is, and I feel that this is a trend that hopefully does occur, and I don't see any logical reason it shouldn't occur. Kind of my last question was an odd one, but you mentioned about the number of public that's for things. What's kind of the reason that we can't have juries in family law? Why is it a judge? Because certainly if it could be a jury, it would be more in favor of the shared parenting. And my understanding is that isn't it in law that we should have that right?
Well, civil jury trials certainly in Ontario are quite restricted. There's a huge cost to the system there, and anyone who's ever gotten a jury duty notice in the mail and instantly thinks about the impact on their household, their job, their kids' needs, and starts to think about whether there's an available exemption or who can they talk to, understands there's a huge burden there. So what we really have to hope for is better educated participants in the system we have, from the judges to the lawyers to the therapists to the assessors, about the fact that we're not doing the best we can do for our children in today's system.
And that's a great point, and I would be remiss if I didn't ask this question. So I know there's not sort of a one fits all tool, but what do you do if you're somebody that faces a high conflict individual, that men or female? So let's say that you're involved in a custody or divorce situation, a separation, and you want to get along, but the other person, maybe their feelings are hurt, about the situation or whatever, or maybe it's their personality, but they're, an aggressive type person, high conflict person to deal with. You have to deal with this individual for the rest of your life. What do you have any recommendations for them based on all your research for your books?
Sure. First, the knowledge base for how to deal with high conflict personas is out there. There's a lawyer and psychologist, well known, named Bill Eddy, who has published a lot, spoken a lot, and you can find his books, etc., if you search the High Conflict Institute, I believe it's called, and lots of really valuable information there, and there are books specifically written about co-parenting after divorce that will usually have a chapter or two about how to deal with a high conflict persona. So you're not completely powerless. There are tips and techniques for how to minimize that and maintain your own space, maintain your own sanity. And in addition, you can get parenting rules imposed by court order. And there are tools specifically designed for these situations. So communications through a web portal called Our Family Wizard, and there's very other similar products that assist in dialing down the rhetoric and making sure that there's an online calendar so everybody knows all the kids' activities on any given day. So there is a lot out there that people can turn to. So hopefully your counsel is familiar with what's available for those situations, and they can make even the most difficult situation tolerable if you yourself are doing the stuff that you can do, which is also taking care of yourself, sometimes developing a thick skin, keeping your eye on the prize, which is how to minimize any stress for the children, and then just enjoying life. And sometimes, you have to put up with a difficult persona, but if you can reduce the impact of that on you and maintain a good attitude, you'll get through it.
Well, I think that's a great place to end, and I'm sure you would advocate, of course, that if people were able to get along and not go to court, that would be a preferred situation. Am I articulating what you would think accurately?
Exactly. If everybody would just do some business in the best interests of the children, I could go back to being a business lawyer full time, and we wouldn't need this huge expensive court system. But it is there because people are having difficulty restructuring in a healthy manner, and it's a bit too wide open now, so some of the things that I mentioned can help, and we owe it to our kids to do better in the future.
Okay, very good. Any last things you would like to say about shared parenting?
Just that people should make their voice heard, and if you're going through your own situation, think seriously about just giving the kids two primary parents instead of feeling the need to be the dominant parent.
Right, and I would just add to that, I mean, I'm a layman, I'm not an attorney, but it would seem to me that you have to get along for a long time, and there's so many different things that can happen throughout the lifetime that your parents that, you know, ideally you would be best to get along, and you know, I think that would be the best thing for the child, and I wish everybody could do that.
I wish so too.
All right, so you know, please, and I'll link all this below, but please tell us the sites that where people can find you, how they can reach you, you know, some of the services that you provide, and any other websites or things like that that you would like to direct people to, and I'll make sure to put it below, but also give you an opportunity to verbally express those things.
Sure. Well, there's a lot of the materials that I've mentioned are either posted on my website or references to them. And so that would be www.ludmerlaw, LUDMERLAW.com. The Canadian Equal Parenting Coalition, which is CEPC.org, I believe. Lawyers for Equal Shared Parenting, if you just search that term, and Leading Women for Shared Parenting. Those are the sites you go to, and you'll have links to all of this social science literature that I've been talking about, various articles as well on the benefits of shared parenting, and some tips to survive the high conflict separation. There's a link to my book on my website.
Yeah, great book. Highly recommend it. And also, you know, I really want to thank you as a citizen because I know that in some ways you're working against yourself. And what I mean by that is that advocating for shared parenting probably would cut down on the amount of a family law legal work. And I'm sure that there's no benefit you get out of this, then you have a true belief in it, and you're doing it because you think it's what's right. So I want to thank you for your participating in trying to make the system better and not just looking after yourself and your own interests in this situation.
Thank you very much.
Well, I appreciate your time, Brian. Thank you very much. Check out Mr. Ludmer's site, and you know, also all the links that I provide below. And if you want a good family law attorney, he's definitely somebody who's very experienced, and you know, can't recommend him highly enough. So I want to thank you for your valuable time, and I really appreciate it.
Thanks.
All right, take care, Brian.